Good morning. Welcome to the Supreme Court of the United Kingdom. This morning we are hearing an appeal in the matter of the Queen on the application of KBR Incorporated against the Director of the Serious Fraud Office. The hearing is taking place online because of the current pandemic. The issue is whether the Director can issue a notice pursuant to Section 2, subsection 3 of the Criminal Justice Act 1987, requiring a foreign company to produce material held overseas. Further information on the appeal is available on the court's website. I'm Lord Lloyd-Jones, and I'm sitting this morning with Lord Briggs, Lady Arden, Lord Hamblin, and Lord Stevens. KBR is represented by Lord Panic, Queen's Counsel, Richard Kovalevsky, Queen's Counsel, and Yamash Hodivala, Queen's Counsel. The Director of the Serious Fraud Office is represented by Sir James Eadie, Queen's Counsel, Jonathan Hall, Queen's Counsel, and Simon Pritchard. Lord Panic.
Thank you very much, my lord. Good morning, my lords, my lady. Our answer to the question that your lordship has summarised is no, the SFO does not have the power that it claims under Section 2, subsection 3 of the Criminal Justice Act 1987 to issue a notice requiring the production of documents held abroad by a US corporation which does not carry on business in this country. And we say that the answer is no for the reasons that we have summarised in our written case at paragraph 5. It's page 62 of the core volume. If I could take the court please to that. Paragraph 5 at page EF, electronic folder 62, we set out 7 points there. Can I just identify them and then very briefly, given the limited time, make some submissions on each of them and address, of course, the respondents' contentions on each of them. First, we say there's a presumption that a statute has no such extraterritorial effect, not least because it would be a breach of international comity. Then we deal with the terms of the Act. They do not suggest a parliamentary intention to confer extraterritorial powers. Thirdly, we draw attention to the purpose of the 87 Act as indicated by the Roskill report. 4, we say there is a clear and settled parliamentary intention to address extraterritorial effect through international agreements. 5th, we rely on the Perry case as the most closely analogous. 6thly, we say this is all a matter for Parliament, not for the courts. And 7th, we deal with the argument about sufficient contention. Those are the matters I want to address this morning. In developing those points, I will make the following responses to what we understand to be the main thrust of the arguments for the SFO. First of all, they emphasise that the territorial scope of Section 2.3 must be considered in the light of the public interest in the effective investigation of serious crime. There is no dispute about that public interest. The question, we suggest, is how Parliament intended that public interest to be addressed in respect of extraterritorial effect. And our case is that the intention of Parliament, as is manifest from a series of acts from 1987 onwards, was to address extraterritorial effect in the context of the investigation of crime through provisions based on international agreements which accord with international comity. And I'll develop that point, of course.
When you use the word comity, Lord Panic, in what sense are you using it? Is this some rule of courtesy, or is it, or are you using it as synonymous with public international law?
It is the former. And that's my second point I wanted to make, because the SFO say that comity is distinct from binding international law. And we accept that. We say their point with respect misunderstands the presumption against extraterritorial effect. It is based on respect for other nations as a value in itself, even if it is not a binding obligation under international law. There is, we say, a strong presumption that Parliament respects comity in this sense because this country would wish to be treated in the same respectful manner by other states. Parliament may, of course, decide to confer on the SFO the powers which it asserts in these proceedings. But Parliament, I submit, would wish to take into account that were it to allow the SFO to impose obligations on foreign corporations in respect of documents held abroad, under pain of criminal sanctions, outside the scope of a bilateral agreement, then this country could not complain if other countries were to impose similar obligations on British companies. And that's why I submit these are matters for Parliament, not for the courts. The third main strand of the SFO argument is to rely on cases concerned with insolvency and taxation. We submit those cases do not assist. They do not assist because they do not involve criminal liability, and in particular, they do not involve a statutory provision in the context of investigation of crime where Parliament has repeatedly recognised the need for international comity. And the court, this court, made clear in the Perry case concerning the SOCA provisions that there is no extraterritorial effect for precisely that reason, unless Parliament expressly so provides. And it did not do so, said this court, merely by conferring a power in that context in respect of, quote, any person. That was the provision in section 3571 of the Proceeds of Crime Act, which I'll come to. The fourth main strand, as we understand it, of the SFO's argument is that Parliament must have intended to allow for some extraterritorial effect. For example, if a domestic company keeps documents abroad. Our response is that the presumption against extraterritorial effect does not apply to a British company or individual, and in any event, any such extraterritorial effect does not assist the SFO to show that the statutory provision applies to a foreign company in respect of documents that are held abroad. My lords and ladies, one preliminary matter can I get out of the way? The SFO written case mentions, it's paragraph 17 at bundle page 97, that the investigation has moved on since the divisional court judgment. The SFO is no longer investigating the Unaoil matter, which was the focus of the inquiry. The SFO say, I'm quoting from paragraph 17 of their case, page 97, separate, discrete lines of inquiry remain under active investigation. My lords and ladies, we do not know what they are. The SFO says that it now only requires the production of 3 items. Those items are mailboxes, they're not specific documents, and we are concerned it would take considerable time, effort and expense to process and review those files, including for legal professional privilege. But we agree with the SFO's invitation to the court, it's paragraph 18 of their written case, page 97, that there is an issue of principle here, and it should be determined on the basis of the position as it was before the divisional court. We have made extensive disclosure of material, but we say we have no duty to provide documents from abroad. We say that will take considerable time, effort, and difficulties, but that's not the basis of our challenge. Our challenge is brought on legal grounds. Now, the presumption, I think there's no dispute, hope there's no dispute that there is a presumption against extraterritorial effect. It is most helpfully summarised by Lord Bingham in the Al-Skaney case, which the court will find at volume 3 of the authorities, tab 41, page 1094, and the relevant passage in Lord Bingham's speech, it was a dissenting speech, but the principle was not in dispute. The principle is set out by Lord Bingham in the Appellate Committee at page 1120, 1120, and at paragraph 11 on that page, Lord Bingham refers to the argument by the Secretary of State in that case. He places heavy reliance on what he describes as a general and well-established principle of statutory construction. That was that unless the contrary intention appears, the Parliament is taken to intend an act to extend to each territory of the United Kingdom, but not to any territory outside the United Kingdom. And to like effect is Lord Roger for the majority at page 1133, paragraphs 44 through to 47. I won't read it all out, but it's there. And at 47, Lord Roger, paragraph 47, Lord Roger states that this presumption does not apply to British individuals or firms or companies. And to like effect, Lord Mance for the court in the Masri case, volume 1, tab 13, page 516 at paragraph 10, which is at page 559 of the bundle. Paragraph 10, again, I won't read it all out, but that recognises the presumption. Now, that presumption was applied by this court in the Perry case, which is at tab 14 at page 571. A 9-member court concerned with the Proceeds of Crime Act, concerned as the court sees with Mr. Perry, who was convicted in Israel of a number of fraud offences, and the agency was seeking both a disclosure order under section 357 and a property freezing order under section 245A. Mr. Perry, as the court sees at page 580, paragraph 5, had bank accounts in London, and at paragraph 6 on page 581, he also had, lucky man, a residence in Mayfair. The ruling of the Supreme Court by Lord Phillips, the President, addressing section 357 is at page 603, paragraph 94. And Lord Phillips, for the majority of the court, says this: the point is a very short one, paragraph 94, page 603. The point is a very short one. No authority is required under English law for a person to request information from another person anywhere in the world. But section 357 authorizes orders for requests for information with which the recipient is obliged to comply, subject to penal sanction. Subject to limited exceptions, it is contrary to international law, I would respectfully suggest international comity, for country A to purport to make criminal conduct in country B committed by persons who are not citizens of country A. Section 357, read with 359, does not simply make proscribed conduct a criminal offence. It confers on a United Kingdom public authority the power to impose on persons positive obligations to provide information subject to criminal sanction in the event of non-compliance. To confer such authority in respect of persons outside the jurisdiction would be a particularly startling breach of international law. For this reason alone, I consider it implicit that the authority given under section 357 can only be exercised in respect of persons who are within the jurisdiction. And section 3...
Forgive me, Lord Penning. Are you accepting there that the references to international law are references to comity, something less than international law, so that it would not necessarily involve a breach of international law?
Yes, my lord, I am accepting that. It is no part of my case to seek to persuade this court that there is some international law obligation which is applicable in this context. It is rather a principle of international comity.
Thank you.
But in my submission, the principle is nevertheless well established, and the section 357 provision, which Lord Phillips for the court was addressing, appears at paragraph 85 on page 600 of the bundle. And the court will see section 357 defines a disclosure order as follows. A disclosure order is an order authorizing an appropriate officer to give to, I emphasize, any person. I'm sorry, Lord Briggs has a question, Lord. Yes.
Lord Penning, just really, the question arises from an understanding that Mr. Perry owned a property in Mayfair. Lord Phillips's proposition, if given full effect, would appear to me, at any rate, to have the slightly surprising context that it would be an offence against comity for there to be a power to acquire information about land situated in England. For example, information about whether it was safe or proposed a risk to the public, of an owner of that land who happened to be based abroad. It seems to me that in the naked form in which the point is put, it may be rather broad, maybe rather too wide.
Yes. Well,
it may be of no great consequence here because the documents in question are not in the UK. But put boldly, it's I would say a startlingly wide proposition.
I entirely accept your lordship's point. I only need to satisfy the court in this case that the principle means that the SFO cannot require a foreign company to provide, on pain of criminal sanctions, information which is located abroad. I don't need to go further than that. And what Lord Phillips is addressing, as I indicated, is a statutory provision for a disclosure order. Although Mr. Perry had property in this country, he was not a British citizen. The information was abroad, and that's the court's judgment in that context. I also entirely accept, and I'm coming on to this, one has to look at the particular statutory context in order to apply the provision. But I do say there's a very strong presumption in a case of the sort that we are today dealing with, that Parliament has not conferred the sort of power for which the SFO contend. We then come, my lords and my lady, to the second heading, which is the terms of the Yes, my Lord Stevens. Your lordship is mute.
There we are. No, I was just wondering whether it needs express words in the statute to have to create an offence abroad, or whether it can be by necessary implication.
It is not my submission that there are no circumstances in which the court could imply a parliamentary intention to give extraterritorial effect. And indeed, in the liquidation context, that was so stated by Lord Hodge and Lord Toulson for this court. So I'm not suggesting one can never imply by reason of the general statutory context, but it would require some very strong contextual argument to justify an implication of extraterritorial effect, not least because there are many statutes where Parliament expressly gives extraterritorial effect to laws imposing criminal offences. Section 72 of the Sexual Offences Act, 2003, page 813, Section 134 of the Criminal Justice Act 1988 on acts of torture committed abroad, page 352. But I don't say never, my lord. I do say that it requires a very strong contextual justification, of which there is none here for reasons that I will seek to explain. So looking at the content of the Act, my submission is that there's nothing in this Act which could justify, as a matter of its contents, extraterritorial effect of the sort with which we are here concerned. Indeed, on the contrary, Section 17, which is page 347, says that the Act, quote, extends to England and Wales only, with specified provisions extending to Scotland, Northern Ireland, and the Channel Islands.
Isn't that an entirely different matter, Lord Panning? The extent of the legislation is something very different, isn't it?
Well, it is different, but it gives an indication that Parliament has expressly considered territorial matters. Again, I don't submit it is decisive of this issue. Similarly, not decisive, but helpful in my submission, is that Section 2.3 is linked to Section 2.4 and Section 2.5.
No, that's it. We'll come to that in a moment. But surely 17.1 is just saying this is part of the law of England and Wales, and it says nothing about the possible extraterritorial application bit. It's the difference between extent and application.
Well, I take your lordship's point. I can't take that further. I take your lordship's point. perhaps more helpful is section 2.4 and section 2.5, which are found at page 341. And those provisions provide for means of enforcement of the SFO's wish to obtain documents, that is, search warrants, powers to enter premises, which cannot have been envisaged to apply in relation to premises abroad. And I draw attention to those because in the Masri case, at paragraph 22, Lord Mance for the Appellate Committee did refer, it's at page 565, his lordship did refer to impracticability of enforcement, those were his words, as a relevant factor in assessing whether a statute was intended to have extraterritorial effect. So I say, putting it at its lowest from our point of view, there is nothing in the Act which positively supports a suggestion that this legislation was intended to have extraterritorial effect. The third point I want to make concerns the purpose, the legislative purpose of section 2, subsection 3, and this is linked to our fourth point relating to what we say is a clear and settled parliamentary intention to address the question of obtaining information to assist a criminal investigation, information abroad in respect of obtaining information to assist a criminal investigation by proceeding through international agreements subject to mutually agreed conditions and safeguards. And we rely on the very familiar observation of Lord Bingham in the Quintavalli case. I won't take time on it, but it's page 1080, that the court will interpret a statutory provision having regard to the mischief which it seeks to address in the historical context in which it was enacted. That's Lord Bingham, Quintavalli, paragraph 8, page 1080. The court will have seen that the historical context of section 2, subsection 3, is that the provision was enacted to give effect to the recommendations of the Roskill Committee, the 1986 Fraud Trials Committee. And the court will find that report, or the relevant parts of it, behind tab 17 of volume 1, page 723, my lords, my lady, page 723. And the Roskill report, of course, recommended that consideration be given to the creation of a serious fraud office. And at paragraph 2.32, which is at page 724, in the middle of paragraph 2.32, the Roskill Committee recognised in the fourth line that the skilled fraudster is likely to do all he can to prevent the investigator from finding and using the documentation in the case. A further problem for the investigator may be that some documents are in the hands of banks and third parties in this country or abroad. In the following paragraphs, we describe the principal powers available to the different agencies. So that's one of the problems that Roskill was addressing. At 241, which is on page 728, the Roskill Committee referred to section 447 of the Companies Act. And it noted that the DTI may, if it thinks there's good reason to do so, require a company to produce its books or papers for examination by departmental officers, and there's a bit of detail. And about 7 lines down, we're told failure to comply with a requirement is a criminal offence. I'll come back to section 447 in a moment. And that's what the Roskill Committee recommend at page 736. If your lordships go to 736, it's the end of paragraph 2.62. Roskill says in the last two sentences on page 736, paragraph 2.62, we see no reason why the powers under section 447 should be restricted to the DTI. In our view, the same or comparable powers should be conferred upon the police. Now, section 447 did confer some extraterritorial power, but very limited extraterritorial power. One sees that keeping open, if one can electronically, the Roskill Committee report, but also looking at tab 1 of the authorities volume, which starts at page 321, and at 327 the court will see the terms of section 447, power to require production of documents, and the power did include at D, 4471D, a power exercisable in relation to a body corporate incorporated outside Great Britain, which is carrying on business in Great Britain or has at any time carried on business there. That was the scope of the statutory power that Roskill was looking at. However, Roskill did not make any specific recommendations about the use of the power it was recommending against foreign corporations abroad. What it did, as your lordship see going back to Roskill at page 737, was to address what it called in the middle of the page foreign evidence separately. And at 5.20 on page 737, Roskill recognised some 5 lines down that the present law in relation to foreign evidence was unhelpful. It referred to letters of request, which was a slow, cumbersome, and not always effective procedure. It then referred to the evidence proceedings in other jurisdictions Act, and its recommendation at 543 was to recommend that legislation should now be sought. This is the third line, 5.43 on page 744, paragraph 5.43. It recommended in the third line that the difficulties being experienced are such that legislation should now be sought to enable oral evidence to be taken on commission abroad for use in criminal cases in England and Wales. Not, I accept, obtaining information for investigation, but for criminal cases. And I'll come back to that point. And at 544 on the next page, page 745, some 6 lines down, Roskill said that further progress in this area should depend to a large extent on conventions, treaties, international agreements to provide for reciprocal arrangements regarding the taking and receipt of evidence. And
sorry, Lord Panic, which paragraph are you on?
I'm at 5.44, my lord. It's on page 745. Yes. And I was referring to some 6 lines down. Further progress in this area should depend to a large extent on conventions, treaties, international agreements, reciprocal arrangements, etc., etc. So that's what Roskill said, and its recommendation is at page 748, paragraphs 26 and 27, 748, paragraph 26 on 748, legislation should be sought to enable evidence to be taken on commission abroad for use in criminal trials in England and Wales. Negotiations should be set in train with other countries to provide for reciprocal arrangements regarding the taking and receipt of evidence on commission. Now, what Parliament did when it looked at this matter was to act on those recommendations, or to consider those recommendations in clauses which were not enacted for reasons I shall mention in a moment. And if your lordships have volume 3 of the authorities, tab number 55, and if your lordship...
Lord Pennick, it may help if I tell you that we're all working off electronic bundles.
I'm grateful. So it's page 1326, page 1326 of the electronic bundle. These were the notes on clauses for the House of Commons for the 1987 bill.
Now, pausing there for a moment, are we allowed to look at these for the purposes of interpretation?
Yes, my lord. Your lordship is allowed to look at material which shows the mischief at which the Act was aimed. And the mischief must include not merely Roskill, it must include how Parliament addressed the matter. And Parliament wanted to include specific provisions dealing with evidence abroad. In my submission, it would breach the principle that Lord Bingham stated to turn a blind eye to what was contained in the very bill which was enacted as the 1987 Act.
The reason I raised the point is a more specific one. There's a first instance decision of Mr. Justice Sales, as he then was. It says that we should only look at notes on clauses if they're public documents.
Well, these are public documents. These were published documents. Notes on clauses were provided to Parliament at all stages. These are not private documents. They're not documents we have access to.
Well,
they're public documents.
They may have been provided to ministers for the purpose of ministers during the course of parliamentary debates, but they may not have been made public. And that's the concern raised by Lord Sales in that case, which I think is called commercial and public unions.
Yes. Well, we have obtained these documents.
For the moment, we can certainly look at this de bene esse, but we may need some help in relation to that at a later stage.
Well, I'm reminded, my lord, we obtained these documents from the Public Record Office in Kew.
Well, that's what I thought. From the form in which the documents are presented, it had the bundle reference.
Yes. Yes, we've not asked for anything that's confidential or that was withheld. These are public documents, and the purpose of them was to assist members of Parliament and when it came to the House of Lords peers to understand the government's intention. My Lord, Lord Stevens has a question.
I was just, if they were obtained from the public records in Kew, there's a habit of depositing documents there many years after the event. And I was just wondering whether they were in fact public at the time that this legislation was passed, because that's not my understanding of these documents. And can I, whilst I'm on, ask the following question as well? And that is, the mischief that I see is the inability to obtain documents from abroad. And you're right, the Roskill report, so far as I can read it, suggests the methods of dealing with that. The remedy is to proceed by way of international agreements. But are we entitled to look at the remedy as opposed to the mischief? Isn't the remedy for the interpreter rather than for the legislator? Because the legislator may have adopted both methods, both remedies. That is, the remedy of making the notice extraterritorial, and also the remedy of proceeding by MLAs. So there are two questions.
Yeah, well, I understand that,
Yeah.
my Lord. Your Lordships and your Ladyship are seeking to identify the meaning of the words that Parliament has enacted.
Yes.
And in doing so, I submit it is important to look at what Parliament intended. And what Parliament intended is to be identified not merely from Roskill, but from how Parliament proceeded. And the reason why I'm showing your Lordship this document as to what was originally in the 1987 bill is because what follows is a consistent line of enactments by Parliament which build on what Roskill recommended and confer specific powers through mutual legal agreements. And in my submission, the fact that Parliament acted in that way is a very strong indicator that Parliament did not intend Section 2.3 to cover the same ground. That's my submission. And indeed, the point goes even further, because the response to the Perry case, which I've shown your Lordships, Parliament's response was not to give the Serious Organised Crime Agency the power that it sought unilaterally to demand information. Parliament's response was to require SOCA to go through a mutual legal agreement procedure, and I'll come on to that. So there's a consistent line of how Parliament has addressed this problem, and this is simply the starting point. My Lord,
It may be your belief that you don't need the notes to clauses and that it's sufficient for your purposes to draw attention to the fact that there was originally a clause in the bill which became the 87 Act, which then reappears in the 88 Act.
Yes, well, I'm grateful. I'm making a meal of it, my Lord. Absolutely. I was referring to this because it's a helpful way of seeing what was in the bill. We don't have the bill in the papers, but I'm sure we can get the court the bill if the court would like to see it. But the bill did contain, in what was originally clause 27, see page 1326, a provision which acted on what Roskill had recommended in relation to information abroad. And I can tell the courts that what happened was that a general election was called, that's public knowledge, in 1987, and the bill was enacted in truncated form. And these provisions, clause 27, which became, see page 1322 in the House of Lords, clause 18, was not enacted. There was a wash-up procedure. And what then happened was that the provision was brought back to Parliament in the Criminal Justice Bill 1988. And we have section 29 of the Criminal Justice Act 1988 at volume 1 of the authorities, tab 4, which is page 349, section 29 of the 1988 Act, page 349, which says, where on an application, page 349, where on an application made in accordance with the following provisions of this section, it appears to a justice of the peace or judge that criminal proceedings have been instituted or are likely to be instituted if evidence is obtained, then a letter of request may be issued. Now, the SFO point out correctly that section 29 was not concerned with the investigation of crime. It was concerned with a later stage. And there are two answers to that. The first is that at that time, that was as far as Parliament was willing to go in relation to material abroad. And our second answer is that Parliament in later legislation, which amended, indeed replaced section 29, expressly expanded the scope of international cooperation provisions to cover the production of material abroad for the purpose of an investigation in this country, and did so subject to conditions and safeguards. The first such piece of legislation, taking it very quickly, is the 1990 Act which is at page 789 of the volume, tab 22, 789, the Criminal Justice International Cooperation Act 1990, the court will see from the long heading, the long title, that it was an act to enable the UK to cooperate with other countries in criminal proceedings and investigations. And the relevant provision is section 3, which is on page 790. And the court will see there that an application could be made to a court either that an offence had been committed or that there are reasonable grounds for suspecting an offence has been committed, and the court could issue a letter of request. And this could be instituted by a prosecuting authority, and under section 3.3, a prosecuting authority is one that is designated. And at 3 subparagraph 7, there were safeguards. This evidence could only be used without the consent of the foreign authority for specified purposes, and it had to be returned if it was not used. The director of the SFO was included as a designated authority at page 794. This is the statutory instrument. Page 794, the director was so designated. The next provision, which applied in this context, is the 2003 Act, which is at page 818. Again, the long title at 818 of the Crime International Cooperation Act 2003 is it's an act to make provision for further cooperation with other countries in respect of criminal proceedings and investigations. And section 7 provides that if it appears to a judicial authority that an offence has been committed or there are reasonable grounds for suspecting, then the judicial authority may request assistance. But under subsection 5 on page 819, the designating prosecuting authority may itself require assistance under this section if it has reasonable grounds for suspicion. So the development is that the designated prosecuting authority no longer needed to go to a court. It could seek the information. And again, the director is a designated prosecuting authority. That appears on page 828 of the statutory instrument. Again, there are safeguards in section 9, which starts at page 821 over to 822. You cannot use the information for any other purpose, and it has to be returned if it's not used. And the court may wish to note that when these provisions were introduced by the 2003 bill, Lord Goldsmith, who was then the Attorney General, explained that these provisions were so important precisely because national law enforcement authorities are required to operate within national frontiers, even though criminals are not so constrained. And the relevant passage is at volume 3 of the bundle, at page 12, page 1302. This is the committee stage of the bill, the 2003 bill. And at page 1303, your lordships will see the observations in Parliament of the Attorney General, Lord Goldsmith, And in the final paragraph on page 1303, Lord Goldsmith says, "It has become apparent to me from my responsibilities as the superintending minister for the Serious Fraud Office that we now face a situation where the threat of crime is global. It's increasingly become global." Page 1304, "Criminals operate across boundaries and without respect for national frontiers through international travel and through cyberspace. National law enforcement agencies, on the other hand, are trammelled by rightly having to operate within our own national frontiers. We respect the boundaries, with the consequence that when it's necessary to bring proceedings in order to investigate crime, which so frequently these days involves a foreign element, the law enforcement agencies cannot do what they would do within their own countries. They have to look for assistance from other law enforcement agencies, often through the courts or judicial authorities of other countries. And that's the explanation for the 2003 bill. An explanation which, in my submission, answers the point put to me by my Lord Stevens, that perhaps Parliament intended in 1987 to give the SFO two options. It could go through section 2, subsection 3, or it could use what was developed into a series of statutory provisions for obtaining evidence abroad. I say no, not merely because section 2.3 does not say or suggest evidence abroad, nor did Roskill, but also because the SFO's argument, in my submission, flatly contradicts what Parliament has done over a series of enactments from 1987 onwards. There's one further statutory development more recently, that's the Crime Overseas Production Orders Act 2019, which is at page 919. But I don't think I need to spend time on that, because that simply applies what the court has now seen in a series of acts to electronic data. It's the same scheme of provision. So our submission is that it is, with respect, exceptionally unlikely that Parliament intended by implication, which is what the SFO have to say, by implication that the SFO should unilaterally have power to demand a foreign corporation to provide documents located abroad on pain of suffering criminal sanctions, when Parliament has consistently focused, beginning with the unenacted provisions of the 1987 bill based on Roskill, has consistently focused on addressing this problem, that is, obtaining information relevant to a criminal investigation in this country, information from abroad, through international cooperation, reciprocity, subject to mutually agreed conditions which respect international comity. The SFO makes a number of points about mutual legal assistance at paragraphs 50 to 52 of its written case. The SFO points out that mutual legal assistance has its limitations. There are some jurisdictions with which we have no treaty, to which the answer is, well, that's a matter for the government. It's a matter for Parliament. It's not a matter for this court. In any event, the answer is that Parliament has addressed the obtaining of material from abroad for criminal investigations through mutual legal assistance to such extent as Parliament thinks appropriate.
There is such
Yes,
forgive me, there is such a treaty in force with the United States, I understand.
there is indeed, my lord. Your lordship
You
and
referred to
ladyship
it in your-
have that treaty. I haven't taken time on it, but it's at volume 1, tab 7, page 379.
Thank you.
The SFO then say, well, of course, it's not compulsory. There's no obligation to use mutual legal assistance where it's available, to which we say that is correct. But that, with respect, misses the point. The point is that Parliament intended that where the SFO wishes to obtain evidence from persons abroad for the purposes of a criminal investigation, then its power is through these statutory provisions which expressly address this problem and which comply with comity. Then the SFO takes a more general point. It says, well, all of these pieces of legislation that I've drawn attention to say nothing about the meaning and effect of Section 2, subsection 3, which was enacted in 1987. To which I have two answers. The first of which is that the 1987 legislation was designed to implement Roskill, and I've shown the court Roskill. I've shown the court how the 1987 bill sought to do so. But secondly, I do submit that it must be permissible where there is an ambiguous statutory provision, such as Section 2, subsection 3. It's at best, from my friend's point of view, ambiguous. It must be possible to construe it by reference to later amendments to the 1987 Act, which I'm coming, and the MLA provisions which Parliament has consistently enacted to address the very mischief that is, how do we combat international dimensions of fraud and other serious offences that Parliament has addressed in the ways that I have indicated. And there's a helpful case that we draw attention to in the Privy Council at page 487 of the authorities bundle, the Hang Seng Bank case at the relevant, it's Lord Diplock speaking for the board, giving the advice of the board, and the principal, sorry, Lord Bridge, I apologise, it's Lord Bridge of Harwich giving the advice of the board. And the principle is that where a statutory provision is ambiguous, the court will give it a construction consistent with subsequent amendments by the legislature. And the principle is at page 504 of the bundle. At the top of page 505, second line, Lord Bridge says the principle is clearly stated by Lord Sterndale, Master of the Rolls, in Cape Brandy. Quote, I think it's clearly established that subsequent legislation on the same subject may be looked to in order to see what is the proper construction to be put upon an earlier act where that earlier act is ambiguous. I quite agree that subsequent legislation, if it proceeded upon an erroneous construction of previous legislation, cannot alter that previous legislation. But if there be any ambiguity in the earlier legislation, then the subsequent legislation may fix the proper interpretation to be put upon the earlier. And his lordship referred to other cases to like effect. Now, the position here is that there are later amendments to the 1987 Act itself. It's not merely that Parliament has enacted a series of statutes which address the very mischief that the SFO are concerned about. It is also that words have been added to the 1987 Act itself by reference to mutual legal assistance. Can I take the court, please, to the 1987 Act? And the court has the 1987 Act at page 336. And if the court would go to page 340, the court will see that Section 2 of the Act with which we are concerned has been amended, and it says at 2.1, the powers of the director under this section, this is page 340, shall be exercisable, but only for the purposes of an investigation under Section 1 above. And then these words were added, or on a request made by an authority entitled to make such a request in a case where there's good reason to do so. And 1A, little b, well, little a deals with the Attorney General of the Isle of Man, Jersey or Guernsey, and b, the request may be made by the Secretary of State acting under the 2003 Act, which I've shown the court. And 1B, the director shall not exercise his powers on a request for the Secretary of State acting in response to a request received from an overseas authority unless it appears to the director on reasonable grounds that the offence in respect of which he's been requested to obtain evidence involves serious or complex fraud. So those provisions amending Section 2 relate to export of information. It's export of information in this country pursuant to international cooperation. And we say that supports our argument that the director was not intended by Section 2.3 unilaterally to require a company abroad to import information through on pain of criminal penalties, and also of assistance in understanding the legislative scheme is that Parliament has introduced a new provision. It's at page 345. It's introduced Section 2A of the Act. 2A1, the powers of the director are also exercisable for the purpose of enabling him to determine whether to start an investigation in a case where it appears to him that conduct to which this section applies may have taken place. And the section applies, see subsection 5 on the next page, page 346, to offences under the Bribery Act. That is cases where there is an allegation of bribery which has no connection with the UK, is performed in a country or territory abroad. That's section 3.6. And section 6 is bribery of foreign public officials. And again, I draw attention to what was said by the responsible minister when section 2A was enacted. It was introduced as part of the Criminal Justice and Immigration Bill 2007. And if the court, please, would go to page 1298 of the authorities bundle, 1298. This was the committee stage, the Public Bill Committee stage of the Criminal Justice and Immigration Bill 2007. And the court sees at 1298 what was being proposed. And at 1299, halfway down the page, Mr. Hanson, who was the minister, moves the clause. And he says this at 1299 in the middle of the page: the SFO has compulsory powers under Section 2 to compel the disclosure of evidence that may be relevant to a current investigation into serious or complex fraud. The new clause would introduce a new Section 2A to allow the director, the SFO, to approve the use of Section 2 at the vetting stage in cases where it appears there may have been a corruption offence involving a foreign official. In practice, the provision will be useful in allowing the SFO to compel British companies involved to provide evidence about possible corruption abroad and then these words, as long as the material is in the United Kingdom. He then says he hopes the committee recognises the government are committed to tackling the corruption of foreign officials. And in the final 2 lines on that page, he laments that in cases of foreign corruption, it's much more difficult to obtain information. Witnesses may be thousands of miles away. Corrupt companies, page 1300, rarely cooperate. And then under the statement of time, 515, he says this: we must deal with foreign corruption as well as corruption at home. Organisations such as the OECD have expressed concern about the UK's record on investigating and prosecuting cases involving foreign officials. The new clause would extend the SFO's compulsory powers to demand relevant material at the vetting stage. The powers will allow the SFO to demand from companies financial information relating to suspect financial transactions as long as that information is in the UK, etc., etc. So when Section 2 was amended to introduce, or rather when that part of the Act was amended to introduce a new Section 2A to cover corruption, bribery abroad, the minister told Parliament that even the new clause, even the new provision, would only extend to information that is physically within the United Kingdom. And it cannot, therefore, have been the understanding of the minister and, more importantly, Parliament, that Section 2, subsection 3 already allowed the SFO unilaterally to demand, on pain of criminal penalties, information from foreign companies which is located abroad. So we submit that all of this is of a piece. Roskill, the original terms of the 1987 bill, the series of Acts of Parliament that have followed thereafter, and the statutory amendments to the 1987 Act itself, both to Section 2 and to introduce Section 2A, and the statements to Parliament by both Lord Goldsmith and Mr. Hanson in proposing those amendments, they are all of a piece. And the piece is that if the SFO, as a designated authority, wants to obtain information from abroad in order to assist it to investigate possible crime in this country, or under the Bribery Act, possible crime abroad, it cannot use Section 2, subsection 3. Its power is to use mutual legal assistance. And indeed, there really is, in my submission, nothing very surprising about that. The very reason why Parliament has gone to the trouble of enacting a series of provisions to make it ever more easy to obtain information from abroad through mutual legal assistance is because Parliament recognises that it is vital to respect international comity, not, I repeat, because it's binding international law, but because Parliament thinks that it is good practice to seek the cooperation of the foreign jurisdiction, and because Parliament knows that it would wish to be treated, it would wish this country to be treated with the same respect were a foreign prosecuting authority seeking to obtain information from persons in this country, and information in this country. So that's what we say about the statutory purpose of section 2.3, the mischief and the way in which Parliament has addressed it. I'm coming on to the Perry case. Before I do, it may be a convenient moment. I note it's only 20 to 12. Your Lordship said around quarter to 12, but this may be a convenient moment if your Lordship...
If it's convenient for you, Lord Panic, we'll take a 5-minute break. Thank you very much.
Thank you very much, Lord. Thank you.
Lord Panic.
Thank you very much, my lord, my lady. Can I turn to the case law? I have already addressed argument on the Perry case, which the court has at page 571. And our submission is that this is a very close analogy to the present dispute. It's a very close analogy because the statutory agency, SOCA, Serious Organised Crime Agency, were seeking information, the disclosure of information for the purposes of investigating alleged criminal offences. The relevant statutory provision, which is on page 600, is in similar terms. It authorises an order to, quote, any person, unquote, and it makes the request punishable by criminal sanctions in the event of non-compliance. And we say that the decision of the court in Perry strongly supports the arguments that we advance in the present case. Of course, I accept that each case where this question arises must be considered by reference to the language of the particular statutory provision and by reference to the statutory context. And I've made my submissions on the language of section of the 1987 Act and on the statutory context in which the issue arises. It may be of some assistance to the court again to see how Parliament responded to the mischief, to the problem. And Parliament responded to the Perry decision by amending the Proceeds of Crime Act 2002 through a provision in the Crime and Courts Act 2013. And if, please, the court would turn to page 927, the court will find the Crime and Court, the relevant provisions of the Crime and Courts Act 2013. Page 927, my lords, my lady. And this is a schedule 19, in fact, to the Crime and Courts Act 2013. And paragraph 24 on page 927, at the bottom of the page, amends the Proceeds of Crime Act. And the amendments are on the next page, page 928, in paragraph 26. Section 375A, it introduces a new section 375A, which is headed Evidence Overseas. And it says this section applies if a person or property is subject to civil recovery investigation, detained cash investigation, or exploitation proceeds investigation. It says at subsection 2 that the judge may request assistance under this section. An application is made by an appropriate officer or a person subject to the investigation, and the judge thinks there is relevant evidence in a country or territory outside the UK. Subsection 3, the relevant director or a senior appropriate officer may request assistance under this section if the director or officer thinks there is relevant evidence in a country or territory outside the United Kingdom. 4, the assistance that may be requested under this section is assistance in obtaining outside the United Kingdom relevant evidence specified in the request. And there's some detail in subsection 5. Subsection 6, a request for assistance under this section may be sent A, to a court or tribunal which is specified in the request and which exercises jurisdiction in the place where the evidence is to be obtained. It may be sent to the government of the country or territory concerned, and it may be sent to an authority recognised by the government of that country or territory. And 7, alternatively, the request may be sent to the Secretary of State with a view to it being forwarded to a court, tribunal, government or authority mentioned. And 375B contains provisions similar to those that the court has already seen in the other post-1987 statutes confining the use of the evidence. And there's then a provision relating to Scotland at page 930. Again, I say this is illuminating because Parliament, consistent with all that I have submitted, has proceeded on the basis not that it will confer on the statutory agency a power to demand evidence from abroad, from a person abroad, on pain of criminal penalty, but rather Parliament has proceeded, as it has done in all the other pieces of legislation post-1987, by saying there is a mischief. The mischief is that potential crime or other wrongdoing relating to fraud needs to be investigated. Evidence is abroad. How is it to be obtained? It is to be obtained by the relevant person, including the statutory authority, going through a mutual legal assistance procedure. And again, in my submission, this helps to answer the question put to me by my Lord Stevens. Perhaps the SFO has options. No, it doesn't. Just like the Serious Organised Crime Agency, which has now changed its name. It's now the National Crime Agency, doesn't have an option because of Perry, and Parliament has not given it an option. Parliament has said, if you want information abroad, this is how you can obtain it. You have no other means of obtaining it. So I rely on Perry. I rely, as consistent with Parliament's approach to the mischief that the SFO emphasise. The approach of Parliament is to not to confer, not to recognise that statutory bodies investigating crime can demand information. They must go through a proper international procedure through the country, the agency, the courts abroad, and there is very, very good reason for such an approach. Now, my friends, Sir James and the SFO rely then on insolvency law, and they rely on tax law. They rely on the cases under those headings. Insolvency law in our submission it does not assist the SFO. It doesn't assist the SFO because the cases self-evidently do not arise in the context of the investigation of crime and the context of seeking information from abroad by persons abroad to assist the investigation of crime. And I've shown the courts the approach taken by Parliament to that specific issue. I've shown the court the Perry case, which addresses that specific issue. The insolvency, the liquidation cases are not concerned with that mischief. They're not concerned with obligations, the breach of which carry criminal sanctions. There is nothing in my submission, nothing in the statutory context of insolvency law comparable to the statutory context in relation to obtaining information for investigating crime, which shows a parliamentary intention to use international cooperation as the means by which information is to be obtained for investigating crime. We are grateful to the courts.
Lord Panic, Lord Briggs has a question.
Sorry, Lord Briggs, I apologise. Lord Briggs.
Yes, Lord Panic, apropos the insolvency comparator, how strong is your point that the obligations in the insolvency compact don't carry criminal sanctions, bearing in mind that the obligation might be, for example, one which is made under a court order, a breach of which would constitute a contempt? I mean, for example, an order to attend to be questioned by a liquidator under section, I think was section 236.
Yeah. Well, I say there is a distinction between that and a statutory provision which expressly provides an obligation to provide documents on pain of specified criminal penalties. I say where Parliament has linked the obligation specifically to a criminal penalty for non-compliance, that brings us squarely within the presumption as to non-extraterritorial effect, and it falls well within the principle stated by this court in Perry. But I recognise your Lordship's point that there may well be undesirable consequences if in the liquidation context there is non-compliance. I have to accept that, and I do. But I maintain also the point about statutory context, and we're grateful to the court, I anticipate, to my lady, Lady Arden, because it was her advice on behalf of the board in the AWH fund case, which has been drawn to our attention for the purposes of this case. I hope your Lordships, your Ladyship, have a copy of AWH available. I don't have a reference for it. I have a loose copy. I simply want to draw attention to paragraph 38 of the advice of my lady for the board, where my lady says, paragraph 38 of AWH, to determine whether section 160 is extraterritorial in its effect, it is necessary to consider that section in its wider context. The wider context includes not only the historical perspective, and your Ladyship explains what that is, it also includes the scheme of the IBCA and the company's legislation which it mirrors. And that has been the thrust of the submissions I've been making to the court this morning. One has to ask the question about extraterritorial effect in the specific historical and legislative context in which the case arises. And the insolvency context is plainly a very different context from that with which the courts were concerned in insolvency. The SFO rely in their written case, it's paragraph 45 at page 106, they rely on a number of cases in the insolvency context, the first of which was Seagull Manufacturing, which is at page 941. And Seagull, it may be of relevance to note, concerned, and I'm looking at page 947 at letter B in the judgment of Mr. Justice Peter Gibson, as he then was for the Court of Appeal, and he notes at 947 of the electronic bundle letter B that the company in question was incorporated in England, and the relevant director against whom the relevant orders were sought was a British subject. That's in the same paragraph. The SFO makes the point in its paragraph 45 that the reasoning of Mr. Justice Peter Jackson in that case was approved by this court in Bilter. And if we just look at Bilter, Bilter can be found, Bilter UK Limited can be found at page 625. And if your lordships would go in Bilter to page 697 at paragraph 212, this is Lord Toulson and Lord Hodge speaking for the court. Lord Newburger agreed at paragraph 10, as did Lord Mance at paragraph 53. Lord Sumption gave a separate judgment, but to like effect. Lord Toulson and Lord Hodge at paragraph 212 distinguish helpfully between jurisdiction in personam and subject matter jurisdiction. And at paragraph 213, they say, in our view, section 213 has extraterritorial effect. Section 213 is set out in paragraph 211 higher up the page. And they say at 213, its context is the winding up of a company registered in Great Britain. So that doesn't, in my submission, take the matter much further forward. The second case that the SFO rely on at paragraph 46 of their written case, page 107, is a case called Mid-East Trading. And that case was a decision of the Court of Appeal. It's at page 1014, and it concerned a company incorporated in the Lebanon, and the Court of Appeal held that there was a power under section 236 of the Insolvency Act to require the production of documents located abroad. The reasoning of Lord Justice Chadwick is at page 1029, and your lordship and your ladyship will see on page 1029 at letter E that his lordship notes the courts have been given power to wind up overseas companies, see section 221. On the winding up of an overseas company, all the provisions of the Act apply, including those which require the liquidator to get in and distribute its assets wherever they may be found. So there's a particular reason in the statutory context of the Insolvency Act why, in the view of the Court of Appeal, an extraterritorial effect should apply, which tells this court nothing about the scope of Section 2 of the 1987 Act. The third case that my friends rely upon is a case called Omni Trustees, which is at page 1200. This was a decision of His Honour Judge Hodge, sitting as a High Court judge, and his lordship held that there was power under Section 236 for the liquidator to require the production of documents abroad. I should mention that the Chancellor, Sir Geoffrey Voss, gave judgment in June in the case of Accurate, inaccurately spelt, Accurate Limited, which we sent through yesterday. It's in something called Supplemental Authority tab 57, so it's on another electronic file. I wasn't proposing to go through all the liquidation reasoning, save to point out that at paragraph 54, the Chancellor concludes that he would decline to follow Omni on the grounds, I'm quoting, I think it was clearly wrongly decided. So one needs to be, I would respectfully submit, a little careful about relying on Omni trustees. But my main point is that, as I've submitted, the liquidation context, for the reasons I've given, is a very different statutory context to that with which the court is today concerned, and in my submission does not assist this court in relation to the issue before the court. The SFO, yes, my lord, Lord Briggs.
Lord Panning, it may be going to be said against you that the parallel is this, that just as in Mideast trading case, the English court was engaged in the winding up of a foreign company, in the present case, the SFO is engaged in investigation of a foreign, or at least partly foreign, suspected fraud. So that where the underlying activity, to use a word that encompasses both winding up and investigation, has a foreign element, then surely the ancillary powers to make that process effective should do as well.
Yeah. Well, my answer to that is one has to look at the statutory context of the legislation with which the court is concerned. There were particular reasons in the civil context of liquidation why the court has the power to call in from abroad assets and information. By contrast, we are dealing here with the investigation of suspected criminal offences, and for the reasons I've given, it is not and cannot have been the intention of Parliament that the SFO, when it is investigating a suspected crime in this jurisdiction, has a discretion to demand, on pain of criminal penalties, information from a foreign company in respect of information that is located abroad. I say that would be contrary to Perry. Indeed, the same reasoning that your lordship puts to me for the purposes of argument could have been advanced, no doubt was advanced in the Perry case. That's precisely what was going on in Perry, that the soccer had a function which was a United Kingdom function. They needed the information which was located abroad in order for soccer to perform the statutory function which Parliament had conferred upon it. But notwithstanding that, the decision was taken by this court that the soccer did not enjoy such a power because of the presumption against extraterritoriality and because of the criminal nature of the context in which the issue arose. So I respectfully submit, if that is the approach for which Sir James is going to contend, his argument, in my respectful submission, flatly contradicts the approach of this court in Perry. He would be submitting that Perry was wrongly decided on that basis. So I rely on Perry, but I also rely on the statutory context here and the way in which Parliament has addressed these issues. And I emphasise, I am not submitting that the answer for which we contend is the answer that will apply in every statutory context. It all depends on the nature of the statutory context in which the issue arises, by which I mean the request or demand by the national statutory authority for information, for assets, for assistance from a foreign person who is abroad. It all depends. But I've made my submissions on why the correct answer is the answer for which we contend in the present statutory context. That's how I put it.
Yeah, thank you.
The SFO also rely on the judgment of the Court of Appeal in the Jimenez case, which is at page 700. This was the tax case, the recent tax case. And the Court of Appeal there held that a notice served by HMRC under paragraph 1 of Schedule 36 to the Finance Act 2008, requiring a British national, I emphasise British national, resident in Dubai to produce information in relation to his tax position in this country can be served extraterritorially on that taxpayer in Dubai. The court may have seen that this court granted that taxpayer leave to appeal in Jimenez, leave to appeal to this court, but no appeal was brought. We assume the case, well, we know the case was settled, so no appeal was brought. We submit that the circumstances of Jimenez were distinct from the present case in important respects relevant to statutory interpretation. First of all, as I've indicated, the notice was served on a UK taxpayer who was a UK national, albeit one residing abroad. And in respect of such a person, there is either no presumption against extraterritorial effect or a very weak presumption indeed, because international comity has very limited, if any, application in such a case. That is what Lord Roger said for the Appellate Committee in our Scaney, to which I've already referred. It was page 1094, paragraphs 46 to 47. There's a secondary point here, but an important point in my submission. Again, there was nothing in the statutory context by which I mean the historical context and the way in which Parliament had addressed the matters raised, to indicate that Parliament believed that such request for information should be addressed through international cooperation rather than a demand from a unilateral demand from the domestic authority. There's no statutory context of the sort that I have sought to show to this court relating to the demands for information abroad relevant to a criminal offence. And thirdly,
indeed, Lord Panic, before you go on, there's a very strong principle, isn't there, that at any rate this country doesn't assist the tax authorities of a foreign country, so that there's a rather large, albeit perhaps traditional, barrier in the way of setting up MLA and that kind of.
Yes. Well, I respectfully accept that, and that shows that helps to show that in that context, Parliament cannot have intended that to be the means. I'm grateful to your Lordship, indeed. There's a third, or perhaps a fourth point then, but it's a point that I don't press in the light of the point made to me a few moments ago by my Lord Briggs, that non-compliance with the taxpayer notice is not a criminal offence. It's a civil matter, but it's nevertheless that is the case, as Lord Justice Patton noted for the Court of Appeal at paragraph 44 of the judgment on page 718. So again, we say, of course, one needs to look at the tax context, but it is very different from that with which the court is concerned in the present context. So my fifth heading is that the reasoning of this court in Perry strongly supports our submissions. The cases in the insolvency context and tax, that is Jimenez, are readily distinguishable. The sixth point that I have is that I say in the context of this case, and it flows from what I've said before, whether the SFO should have the power that they assert is, in my submission, a matter for Parliament. It's not a matter for the courts. The extraterritorial application of an investigatory power involving criminal sanctions, where the regulatory authority purports to exercise those powers in relation to persons abroad, in relation to documents abroad, engages issues of international comity. And these are matters much more appropriate for the legislature to assess than a court. Why? Well, because it's for Parliament to decide, as it has done in the statutes that I've shown the court. It's for Parliament to decide what conditions should be imposed and what safeguards. And that's what Parliament has done. And my lady has a question for me.
Thank you. Does that mean in practical terms that the courts have to look for express wording giving extraterritorial application? And if I could just intervene with another add-on, why is it that comity does not permit the implication of extraterritorial application in this context, but does in relation to tax or the previous example? If you could just help us a little bit more about comity, I should be appreciative, not necessarily now. But my first question is one of statutory interpretation. Should we be looking, as perhaps Lord Stevens had said, to express wording now when it comes to ETA?
Well, in my submission, in this context, I say it is very difficult to see how one could imply the sort of authority for which the SFO contends. I so submit because Parliament has addressed precisely this mischief and has done so expressly in the series of statutes that I have drawn to the attention of the court. And I do say, following the approach for the court of Lord Phillips in Perry, that it would require something quite extraordinary in the statutory context for the court to imply the powers that the SFO is contending for. I would not submit that it couldn't be done. There might be something, for example, in what the Minister said to Parliament. It might be something in some other document that satisfies the court that the power can be implied, but it would require something quite exceptional. And there's absolutely nothing here that comes close to justifying the sort of implication for which my friends contends. Comity in the tax context, I repeat that the court was concerned in Jimenez with a British national in relation to British tax affairs. And in relation to that, Comity has no, in my submission, has very limited, if any, I would say no role to play. It isn't a breach of international comity for the tax authorities of this jurisdiction to wish to have information to assess the tax position of a British national in relation to his tax return. I would also rely on the point that was made to me by my Lord Briggs, that in the context of tax, international states are not expected to assist each other in relation to tax affairs. That's the submission that I would make, adopting the point that was put to me. Those are my answers to my lady's questions. It may be of interest, but I don't take time on it. It may be of interest for the court to note that a very similar problem was addressed by the United States Court of Appeals Second Circuit in the Microsoft case, which the court has in the bundle at page 1225, a decision in 2016, and a very similar question arose as to whether Microsoft could be required on pain of criminal penalties to provide information relating to persons abroad, foreign persons abroad. And the United States Court of Appeals said no, and the consequence was that the United States Congress enacted legislation expressly providing for extraterritorial jurisdiction. So I draw attention to that as an item of interest. I don't suggest in any way, of course, that the court is bound by that. Of course not, but it may be of some interest for the court to look at the approach of the United States Court of Appeals. That was my sixth submission. I noticed the time. I have a seventh and final submission. I say that the court should resist the suggestion made on behalf of the SFO that the court should imply into this statutory scheme of the 1987 Act a, quote, sufficient connection, unquote, test. The SFO's position in its written case at paragraphs 54 to 55 is that it is not contending for a sufficient connection test. Indeed, it makes the point, the SFO makes the point, that there is no such test written into section 2, subsection 3. We agree, and we draw attention to the fact that where it wishes to do so, Parliament is perfectly capable of incorporating into a statute, a criminal statute, a sufficient connection test. It's done so in section 12 of the Bribery Act 2010, page 916. But the SFO, as a second string to its bow, suggests, page 109, that if the court is against it on its main submission, then its secondary position is that it will accept gratefully a sufficient connection test. We respectfully quarrel with that. The SFO say there are a number of safeguards already in this legislation: judicial review, a reasonable excuse defence for prosecution, reasonable grounds for suspicion. Of course, none of those so-called safeguards address extraterritorial effect and the issues that we have been addressing. I should add, although it's not central to the case before this court, that the alleged safeguard of judicial, or on the alleged safeguard of judicial review, good luck to anyone who tries to challenge a decision of the SFO to exercise its powers under Section 2.3 on conventional judicial review grounds. Sir James would, as he always does, powerfully, eloquently tell the court that the SFO enjoys a very broad discretion in relation to this discretionary power. In my submission, there is no basis for a sufficient connection test, and in any event, if that were the test, we would respectfully dispute that there's any sufficient connection in the circumstances of this case. We are a US corporation. We've never done business here. The relevant documents are abroad. The test cannot be, even if there is a sufficient connection test, it cannot be a test of whether there's a close connection with the investigation. As I've said, that will always be the case. Otherwise, the documents would not be relevant, and it would have provided an answer in peri. We have no sufficient connection with this jurisdiction for the purposes of this matter. But my main submission is that Section 2.3 does not confer the sort of power for which the SFO contends, for all the reasons I've advanced. I've used up my time. I will happily seek to answer any other questions the court wishes to put to me, but subject to that, that's what I wanted to say on behalf of the appellant.
Thank you, Lord Panic. It doesn't appear that there are any questions for you at this stage. Thank you very much.
Thank you,
Sir
my lord.
James.
My lord, my lady, just to sweep away some ground at the outset, I'm hoping you can hear me.
The sound is a little distorted, Sir James, at the moment.
Oh, I'm sorry. Is that better or worse?
It's about the same, actually. Carry on, and we'll tell you if there's a problem.
Thank you. There is no challenge in this case to the relevance of the material to the investigation of the SFO, to the proportionality of the categories of information sought, to the fact that it would be entirely lawful under local US law for the demand to be complied with. There is no suggestion that it would be unreasonable in any other way for there to be compliance by KBR Inc. with this request. And there is no challenge to the manner, no remaining challenge given the grounds of appeal, to the manner in which service was effected. The challenge is therefore a very narrow one. And the question is whether there is a jurisdictional bar for giving notice under Section 2.3 to any foreign company in respect of any document abroad, regardless, therefore, of their relevance to the investigation. And we do submit that the judgment below at paragraph 70 correctly defined that narrow jurisdictional issue by reference to the matters that were and were not in issue. And the appellant's case is that Parliament did not intend to permit the SFO to give notice to a person in England where the company, the subject of the notice, happens to be incorporated abroad and the documents in question are abroad. I think it's that combination which they rely upon. And I wanted to start, if I may, with 4 key points in relation to the statutory context in which this legislation sits, and thus the intention in this regime to ensure that the SFO can conduct the functions for which it was set up effectively, by which I mean accessing and speedily and efficiently accessing information relevant to its investigations. The first point of context is that the SFO investigates serious, complex fraud, including bribery and corruption, and those cases very often have a strong cross-border element. Indeed, fraud, bribery and corruption cases are also likely to involve both complexity, so that the investigator needs to get access to all of the documents and information available to enable the picture properly to be understood and the trails of investigation to be properly followed. Those sorts of cases also involve a strong incentive to disrupt that ability by those who are responsible. But as I've said, in terms of corporate bribery and corruption, the cases will very often involve operating in relation to international transactions with events in multiple jurisdictions, documents and companies spread across multiple jurisdictions. The point was put pretty crisply originally by Sir Donald Nichols when he was Vice-Chancellor in Paramount, picked up and repeated in the AWH and ZCN case at paragraph 39, to which the party's attention was helpfully drawn yesterday. As Sir Donald Nichols put it in Paramount, quote, "Trade takes place increasingly on an international basis, so does fraud." And you may well have groups of companies operating for a single purpose, which may be corrupt, but with disparately located functions within that group. So the negotiation of a corrupt contract, for example, in one jurisdiction, maybe even the raising of an invoice in another, and the approval, the treasury functions in a third. That's the first point about the nature of the investigations that we're dealing with. The second point is that it is highly likely that many of those who might hold documents, given that type of investigation, many of those who might hold documents are, as here, foreign corporations. They may have greater or lesser connections to other parts of the group incorporated in the United Kingdom. They may have more or less practical, functional connection to the United Kingdom. There may be divisions of both function and personnel within the group, depending upon precisely how the group itself in legal terms and its functions and personnel in practical terms is set up. We see that feature being clearly set out. If you go into the judgment in the court below, in the appendix at electronic page, paragraph 9 of the judgment, it's electronic page
120, I think.
120, yeah. You get that description of how KBR operates between paras 4 and in paras 4 through to the end of 8. And we've summarized it in our case at paragraph 9 as well. And this practical reality we submit is powerful against the hard precluding line based on the fact of incorporation abroad, the mere fact of incorporation abroad, plus one might add, in the modern world, with statutes pursuant to well-known canons of interpretation being always speaking in relation in particular to technological and scientific developments, emails held on foreign servers or documents otherwise held abroad. I mean, the emails on foreign servers is the classic. because no one has the slightest idea in most cases where on earth an email is physically located. If it's taken to be the place of the server, you could have a company operating out of New York, which does business primarily in London with all its personnel based here, and the servers happen to be in Vanuatu, or located in a cool, refrigerated environment in the middle of the Pacific Ocean.
But so James, it's surely not being said that merely because the server on which the email is held is in Vanuatu, a copy of that email available on a London-based computer is not a document located in the UK, is it?
Well, the document, you could have a debate about that. I'm not suggesting that, no. I'm simply illustrating the broader proposition, which is you're trying to deal with what Parliament's intention was when setting out in relatively broad terms the powers that are available to the SFO. And critical to that statutory context, I submit, is not merely the nature of the investigation which the SFO, or the investigations in plural, which the SFO can be expected to undertake, but how in the rural modern commercial world, and my lord will need no education in relation to that, businesses set up both their place of incorporation, their practical and functional operations, and indeed the location of any documents.
But is the case, is the line simply drawn along place of incorporation? I mean, we can think of a company that's incorporated abroad, having its management in another place and carrying on business in a third place. I'm not sure I understand the objection to the Lord Panic's objection is simply based upon the place of incorporation.
It isn't. I made it very clear, I hope, at the outset that as we understand this case, it's based on the combination of the features.
Yes.
Incorporation plus documents or material abroad. I think
even accepting that duality, one side of it is where is the respondent to the notice, and I'm questioning whether the identification of the place where a corporation is always governed by its place of incorporation. It may be governed, often is governed in European law by its COMI, and it may be governed by the place where it does business, because in this modern world, a company in Vanuatu can do all its business in England if it wants to.
Well, it might do, and I can accept all of that. The point that I make is that you don't end up with sharp, hard-edged lines. It'd be very surprising if the hard-edged line of the mere fact of incorporation were the be-all and end-all in terms of the ability to get hold of things. To some extent, the more complexities and differences that there are in relation to both the fact, or both the place of incorporation and document holding, and indeed functional setup within groups of companies, all of that is grist to my mill, because all of those things are likely to need to be investigated, and in the context of complex international fraud, those features are truly adventitious in terms of the effective pursuit of the sorts of investigations, transnational as they often will be, with which we are concerned. And so the third point I was going to make, the first one was really focused on incorporation and the complexities associated with that. The third one was in relation to the creation of documents, likewise likely to be spread across the world, across the group, documents held in servers accessible in England or located on a server in the United States, wherever else it may be. And as I've said, an adventitious mechanism of jurisdictional control, particularly if, as appears to be accepted in relation to location of documents, the documents abroad of an English company could be called for, even on my learned friend's case. And the fourth point is the obvious one, which is that documents falling within this combination, some form of foreign corporate element plus documents abroad, may very often, especially given the nature of, for example, bribery and corruption investigations in international transactions, critical to the effective investigation of crime. And for that purpose also, paragraphs 4 to 8 of the Divisional Court's judgment give you a clear example of why that should be so, my Lord Stevens.
Right. I was just perhaps taking it slightly out of your way, but my understanding is that you say that any person includes a foreign person as well as a person within the territory. And I was wondering whether or not you are submitting that any person, for instance, could include the law enforcement agency in the US. For instance, in this case, the SEC, who no doubt will be holding documents which would be relevant to the investigation. And if it does, then serving a notice on somebody from the SEC who happens to be in the United Kingdom would lead to the potential for criminal penalties to be imposed on a law enforcement agency in a foreign country. And so I was just wondering whether or not you are, the sufficient connection test is one that you don't adhere to. But are you submitting that there is a discretion on the the director to serve a notice on a law enforcement agency in its country?
My Lord, I can see the difficulties with making that submission. And I think my short answer to that is that I don't need to. And I know one can test the principle by saying, well, does it go that far? But for present purposes, we are only concerned with private and indeed linked.
At present, I struggle to see if you have a wide interpretation for any person that doesn't include a law enforcement agency, and so that the director would be interested in getting documents from another law enforcement agency.
Yes, but of course there are obvious problems with trying to impose any sort of penalty or liability on a foreign state. In other words, the entities of a foreign state which perform its sovereign functions within its state. So there is a distinction in principle, and I suspect very much that international law would recognise that distinction between, on the one hand, true state agencies in a sovereign foreign state, on the one hand, and on the other hand, private individuals or persons, including corporations.
And would a police force be a state agency subject to immunity from prosecution?
It would be an emanation of the state, plainly. I mean, it wouldn't depend upon the precise breakout under international law as to how that worked, but I would accept the police force would fall within that category.
And so therefore you couldn't do it within the jurisdiction and serve a notice on some agency, law enforcement agency within the jurisdiction?
I don't make that positive case, no.
Thank you.
Well, the stages of the argument, if I may, just in a series of propositions to try to keep it as short and responsive as possible. The first and critical stage of the argument we submit is that there is a very strong public interest in ensuring effective investigation by the SFO. And that public interest is both a national public interest, but also a powerful international public interest. As one sees, for example, from the OECD Convention itself. I don't invite you to turn it up now, but you can see very clearly from page 355 in your authorities bundle, volume 1, in the preamble to the convention, that it internationally recognized public interest. 355, and it's really the third of the preambles, having regard to, and so on. And that effectiveness of an investigation has got to be allowed, we submit, to operate in a sensible and efficient way. There are, of course, a variety of different ways in which it can be assisted and effective. My lady, yes, sorry.
So just going back to the bribery convention and the recitals, can we really take the bribery convention into account, although it's dated 1997, because it was not incorporated into UK law until 2003, or rather the measures necessary to enable the UK enforcement agencies to investigate the bribery, let us say, of foreign public officials in their own countries.
My lady, I entirely take the force of that point, and as a pure point of interpretation, you are of course right. But the reason for drawing attention to this is simply as a convenient way of recognising what has always been an international public interest. There has always been cooperation and a mutual public interest in against, if I can put it this way, bribery and corruption in international transactions. The OECD Convention, therefore, is simply a convenient way of expressing that. So if it introduces some new point, well, so be it. But I rely on it for the slightly broader purpose.
Thank you.
Just a minute in relation to this public interest, to the reasoning of the divisional court below, if I can invite you to take up the divisional court's judgment. And the paragraphs I want, which I respectfully submit are really key to the reasoning of the court below, are paragraph 68 and 69 on electronic page 136. Can I just invite the court to refresh your memories of those paragraphs? I'm sure they'll be familiar and marked up already, but including the last sentence of paragraph 68. And those paragraphs we do submit provide the critical context in which the issues of interpretation arise, not least because legislative purpose is very often the prime interpretive directive, if I can put it that way. And we do respectfully submit that the comparison with other regimes, which you saw referred to in paragraph 69, does indeed, as the court below found, support the ability to use this power territorially. In our case, we've dealt with the insolvency and tax authorities in our case at paragraphs 45 to 47, and it might be thought that those contexts are a fortiori at the present, given the increased public interest in the effective investigation of activities that might be criminal. And that provides the distinction in terms of outcome between, for example, insolvency on the one hand and the Masri context on the other. But in Masri, as you will recall, at paragraph 23, I don't invite you to turn it up now, it'll be very familiar, Lord Nance, para 23, page 566 in Masri, recognising the strength of that public interest in the context of insolvency. He wasn't then dealing with tax, but the insolvency context, strong public interest, clearly recognised. And the distinction in Masri was that the court was there dealing with private interests, in other words, private litigation, as compared to the public interest that arises. And you get the same recognition of the public interest in the tax context. Again, we submit a fortiori here in the Court of Appeal case in Jimenez, which is behind tab 16 at page 717 at paragraph 39. Turn that up, 717, para 39 of Jimenez. And whilst you're there, just on a point that I think Lord Briggs was expressing interest in, which is, well, you don't have quite the same MLA. I'm going to come back to MLA, mutual legal assistance conduct. You don't have quite the same thing in relation to tax, I think was the thrust of the point that my learned friend Lord Bannock adopted from Lord Briggs. And true it is that there is a principle of conflict of laws that foreign jurisdictions, and indeed our jurisdictions, won't lend their hand to the enforcement of certain types of law, penal and or tax, being included within the categories. But there are, as is entirely unsurprising, equivalents of MLA between various jurisdictions to provide for the flow of information in relation to tax affairs by reference to those arrangements. As one sees, it was a point that was taken against us there in Jimenez and was rejected. See paragraphs 42 and 43 on the facing page. I should have a facing page electronically, but 718. So you do a series of mutual arrangements in relation to tax, which includes flows of information and so on. So we do respectfully submit that those contrasts, those analogues, as it were, of course they're all different. We all agreed about that, but we submit that for relevant purposes, they are, in terms of the public interest and the strength of it, a fortiori, where you're dealing with the public interest in the protection of society, including international society, from crime. My learned friend referred you to the new authority that he had produced, which was the inaccurately spelled accurate decision. And again, neither of us, I think, are going to make a great song and dance about that case. But in fairness to the Vice-Chancellor, I don't want to be overstating it, but it looked as though he was dragged, as it were, kicking and screaming by the doctrine of precedent to a place of concluding that at least one of the sections in the Insolvency Act did not have extraterritorial effect. But the interest perhaps for this court, which approaches matters with a far greater weather eye on first principles, is the extreme reluctance with which he did so, and his specific agreement with, in particular, the purposive points which had led Lord Justice David Richards to express the view that if he'd been coming at it from first principles, he might have reached the opposite conclusion to the conclusion reached by the Court of Appeal in Tucker. See in particular paragraph 53 of that decision, inaccurate, which I don't think you have electronically, but was a late addition to the bundles. It's also worth, just on this first point, and perhaps as part of the analysis of the strong public interest in an effective investigation of this sort of crime, it's perhaps also worth noting that an overseas company, perhaps even an overseas company in the position of KBR Inc., at least could be liable to prosecution in the United Kingdom for bribery. The punchline being, I think this was the point that Lord Briggs was putting to my learned friend, an odd disconnect if you could prosecute a foreign company, but you couldn't investigate it effectively. If, as part of that effective investigation, you needed to see documents which it held. And I say that you could prosecute a foreign company for bribery in this jurisdiction, the way in which the bribery offence under Section 1 of the Bribery Act 2010 is set up. It's triable in the United Kingdom if any part of the offence occurred in the United Kingdom. See Section 12.1 at electronic page 916. So if a US company participates in a bribery by knowingly making payments from the US on behalf of a UK-based company, the US company could be indicted under at the very least, joint enterprise principles, and tried in the UK. And of course, liability extended under section 14 sub 2 of that Bribery Act to liability on senior officers, quote, who consent to or connive in the bribery offence by a corporation. So we do submit that that's also an important point of context. If you can prosecute the foreign company here, it will be, we submit, deeply surprising if you couldn't access the relevant materials when seeking to work out whether they had been involved. And again, go back to the divisional court's description of the facts that they were considering at paragraphs 4 to 8 of their judgment, including in particular paragraph 8 dealing with the clearance, if I can put it that way, of the payments suspected to be that were to be made by the UK company, which had entered into the agreement with the consultant, in inverted commas, cleared through US Treasury functions, cleared by people who were located in significant part in the United Kingdom, cleared in relation to the activities of the UK company. So that doesn't just illustrate the contextual points I was pointing to at the beginning. It illustrates that this, if made good, could found offences against both foreign officers and foreign companies. Why then should not be intended the investigation of that possible triable crime? Why should they conclude that that should stop at Dover? My lady, so that's the first of the stages of the argument. The second I can take pretty shortly, and it may be the last one before the short adjournment. But it is that broad language is used in this legislation. It isn't territorial only language. It includes persons under investigation. It includes any other person. It includes any specified documents. And we do therefore rely on the reasoning and thinking of the Privy Council in AWH against ZCM at paragraph 37, where reliance was placed on the use of the word any as at least being indicative that the provision in question was capable of extraterritorial effect. So far as my learned friend's point on the remaining provisions of the actual Act that we are dealing with, he placed reliance on section 17 first. The short and complete answer to that was, with respect to the one given by my Lord Lloyd Jones, that's about extent and application. That's the distinction that deals with section 17. Section 17 tells you nothing about the application of the substantive provisions. It tells you in the usual way where it applies within the United Kingdom. But then my learned friend says, well, there are separate powers which plainly could not be exercised abroad, searching premises, for example, search warrants. And we accept that they could not be exercised abroad, sections 2.4 and 2.5. But the short answer to that is that those are separate powers. True it is, existing in the same legislation, but there is nothing to prevent different powers being capable of exercise, subject, of course, to international legal limits, which provides the backdrop and the break for 2.4 and 2.5, but nothing to prevent them having different spheres of operation. The mere fact that they sit within the same legislative scheme is neither here nor there. The control is provided, if at all, by broader principles, including specifically and in particular international law, and we note and recommend, if I may respectfully do so, the reasoning on a precisely similar point that was sought to be run and was rejected by the Court of Appeal in the Jimenez case, paragraphs 33 and 33 of Jimenez on page So 33 and 34, rejecting that argument on pages 715 to 716 of the electronic bundle. My lord, that might be a
Convenient point. Sir James, thank you very much. It may be that we can assist over the adjournment with the slight distortion, which is still reaching us. But
I'm sorry about that. I'm afraid Mr. Sheck might have tried.
Nothing to apologise for. It's certainly an acceptable standard, but it may be that we can help it over the adjournment. But in any event, we will resume at 2 o'clock.
Very well.
Thank you all very much.
Perhaps if I stay on and Mr. Sheck stays on, we can...
We'll ask Mr. Sheck to stay on and see what he can do.
Thank
Thank you
you
very much.